Nisqually, your name, please.
My name is what you asked
Yes.
for?
I did.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
And how do you choose to go forward?
Pro se, please.
Okay.
Your Honor.
You even know the right term. Okay.
And there's no victim in this alleged crime. I might preface this with, I have gone to anti-kidnapping training. I was inhumanely subject to what I would define as torturous.
Today we got one of the most bizarre and frankly embarrassing courtroom moments you'll ever see. This guy is trying to use the same old sovereign citizen arguments, like there's some kind of magic spell that will get him out of trouble. But spoiler alert, it doesn't work. The judge can barely keep it together. And honestly, who can blame them? How do you even argue with someone who's that out of touch with reality, acting like their made up rules matter more than the law? At some point, these people have to realize that their sovereign citizen nonsense doesn't stand up in a court of law. I just can't believe we have this many people still out there pushing these ideas, especially when they end up looking this clueless. In court, what do you think, though? Let me know in the comments. How do you think this guy's logic holds up as we dive?
I am not represented by anybody besides myself. In my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting Ms. Langley go.
I read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, though that language doesn't make any sense. So
no, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's
I'm not a person. I am one of the people. Thank you.
Okay. Thank you. All right. So for the record, that's my finding. Yeah, hold on. We're not done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony and probable cause application to be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too drunk to be held accountable.
And what's going on, you'll see the frustration starting to build as a sovereign citizen refuses to listen or follow basic legal procedures. The man in question, Peyton Ansley John Milton. And yes, he insists his name is written in all caps for some reason, is trying to represent himself in court. When asked about whether he is a lawyer, he proudly states that he doesn't need one because he's representing himself in his sovereign capacity. If you're wondering, that's just legal gibberish, and the judge is clearly not impressed despite being told that he's facing serious charges. Milton doesn't want to hear anything about his rights. He's convinced that by using the sovereign citizen script, he can bypass the law entirely. The judge and prosecutor have their hands full just trying to deal with the nonsense this guy is throwing out. It's almost like watching someone try to negotiate with reality itself, only to get laughed off the stage then. As the hearing continues, the judge starts to ask some important questions, trying to figure out who.
7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" The officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. Then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Payton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. The Nisqually jail.
On the charge of criminal trespass first degree, is the city making a motion to revoke the deferral on the assault conviction or
Yes,
on the
Your
assault
Honor.
case?
Based on the new law violation, yes.
Thank you. And let's see.
Now, will I get a moment here to articulate anything?
I'll let you know. So sit
Appreciate
tight.
it.
I'm still working through the process. Thank
Of
you.
course.
All right. So, Mr. Sharp, it appears that the assault was not a deferral. It was a stipulated order of continuance.
That's correct, Your Honor.
All right. Thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Mr. Milton is asking not to be represented by counsel. Is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice. But I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that information, actually.
Okay. So not being an attorney, you understand that if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney. So you will end up missing things you're supposed to do. You will do things you're not supposed to do. And all of those things will likely work to your detriment. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision to make. You, however, have that right, as I pointed out. But I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay,
Your Honor.
even know the right term. Okay.
Your Honor, I was not read my Miranda rights this most recent time. I believe I'm supposed to request a
Meaningful conversation when the person you're dealing with refuses to speak in any way that makes sense. The case itself stems from a situation where the police were called to a 7-Eleven after a man, Milton, was causing a scene. He was intoxicated, belligerent, and refusing to leave when asked. In fact, he even told the staff he'd be waiting outside after they got off work. The store employees didn't feel safe, so they called the police. When the officers arrived, Milton was found outside his car still, not cooperating. This is just one example of how these sovereign citizens get themselves into trouble by refusing to acknowledge basic laws and social norms. The whole thing just ends up looking like a circus with no one willing to take responsibility for the situation they've created. The situation escalates when the officer makes contact with Pito and Milton, quickly identifying him as a local transient who lives out of his car. The officer knows Milton, while having dealt with him several times. before when asked if he had been inside the 7-Eleven Milton.
Present you, you're going to have to figure all that out yourself for purposes of today.
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court order.
Read your form on your constitutional rights?
Did I read my form? I don't believe I was provided anything.
Okay. Is there a corrections officer there?
Mr. Upton?
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it, and then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay. Why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't been Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged crime.
I know. All I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence yourself? Forgive me.
And actually, Ms. Langley, if you'll unmute, because I have some questions for you regarding other cases.
I have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay, thank you. All right, so the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance, and the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was not in possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key.
Okay. Anything else?
That's it for now.
Okay.
Unless you would allow me to fill in some details that they failed to read me my Miranda rights, and I wasn't taking a statement from in both questioned cases in question.
All right. So what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. It doesn't mean they can't go forward with a criminal charge.
I was never aware of that.
Accountable for his actions out of everything. He could have said this sovereign citizen tries to dodge responsibility by outright admitting to committing the crime, but then claiming he's too drunk to face the consequences, talk about a lack of accountability. Honestly, I don't know how these sovereign citizens can think they'll get out of trouble by spitting out nonsense like this. They act like the law doesn't apply to them if they just say enough crazy stuff. I just can't wrap my head around how you could be caught committing a crime wasted and then try to dodge responsibility by playing that I'm too drunk card. It's almost like these people live in a victim mentality bubble where they think the system is always out to get them. But let me know what you think. Are these people genuinely victims in their own minds? Or is this just another instance of someone trying to escape the consequences of their actions? The officer explains to Milton that he's trespassing and needs to leave the property. Milton acknowledges it, but then offers to push his car out of the parking lot as he's too intoxicated to drive. The officer agrees and gives him some time until nightfall to move the car to a nearby gravel lot.
Right, which is one of the reasons don't want to represent yourself, but I've explained that to you now. But I just want to make sure. So you still wish to represent yourself?
Absolutely.
Okay. All right. Seem like a sharp guy, so
Appreciate you, Your Honor.
seem dedicated to do it. Okay. Based on the outstanding warrant out of Skagit County, I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol and marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
If the minimum that I'm allowed to throw on a bail is 300 and I have to bail out for two things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible this time around.
Okay. Well, you may know from your history that the bail here is usually 10% of what's ordered, so $50 on each case is what a bonding company would want from you. So just, I don't know whether that
Well, I have
changes
$100.
anything.
Isn't that
Okay. All right. I will set this for 3 weeks from today at 1:30 in the afternoon, so on Monday the 24th of April, for what we call a pretrial, Mr. Milton. And at the pretrial hearing, you will have received information from the city prior to that as to any offer to settle the case, just so you know you don't have to accept it. But they will be contacting you to give you whatever offer they have. And then you'll tell the court at that time whether you wish to accept the offer and enter whatever arrangement is made, or whether you wish to go to trial. So that'll be what we discuss on the 24th.
Awesome. In the meantime, will I be allowed 4 to 6 hours of unhindered internet access so that I can represent myself?
Yeah, I do not regulate the jail, so you're going to have to talk to the folks at the jail.
If you write it as a court order, I'm certain that they will be more likely to comply than if you don't.
All right, I'm not going to write it as a court order. Like I say, I don't mess with how the jails run their jail, but
speaking of, by the way,
Mr. Sharp has heard you, and we'll go forward that way.
On a side note, if I may, Your Honor, during intake, and I might preface this with, I have gone to anti-kidnapping training. I was inhumanely subject to what I would define as torturous actions. It was by C.O. Patero. I have nothing against the man, but he only sought to escalate a situation physically that could have been de-escalated with a verbal warning, a verbal, hey, knock your stuff off, a verbal. And I was completely compliant physically, as you can see on camera if you look in holding C on the night that I was intaken. And when I was asked to be picked up and seated, they had refused and told me on their paper that they checked on me every 15 minutes when I was checked on about 3 times the first 2 hours and about twice in the last half an hour. So,
all right, we got that.
And warns him that if he returns to the store, he'll be arrested. Sure enough, not long after the staff calls dispatch again to report that Milton has returned to the store. When the officer arrives, Milton repeats that he's too drunk to be held accountable, but this time he leaves his phone behind in the store. The officer finds him again, still clearly intoxicated, but functional enough to understand what's going on. Milton is arrested for trespassing and taken into custody. Without incident, the case continues with the city now looking into revoking a deferral from a previous assault conviction. Because of this new law violation, the legal process starts to unfold, and it's clear that Milton's reckless behavior is catching up with him despite his attempts to avoid responsibility. Now things get even more interesting when Peyton Milton decides he wants to represent himself. In court, the judge gives him a fair warning. Representing yourself is a right, but it's also a risky decision. The judge wants to make sure Milton understands exactly what that means. After all, it's not like anyone in the courtroom is going to help him out. If he messes up, the judge asks Milton if he's been to law school. And of course, Milton dodges a question giving a nonsensical answer. I can neither confirm nor deny that information. We all know where this is going. The judge lays it out clearly. Without an attorney, the court cannot assist him with legal procedures. Milton will likely miss important steps and make mistakes which will only hurt his case. The judge tells him straight up that even an attorney would be